Hi, I'm Joey Jackson. Today I want to give you a little history lesson on the issue of discipline. It has been noted and said that there's more discipline ever in the history of the Correction Officers Benevolent Association. Let me give you context and perspective. And how would I know? Because I've been there. Let's go back to the 1990s. Yes, that far. For 25 years, there was, up until 2020, the situation in terms of discipline where correction officers went to oath 1 day a week. The calendar had about 10 officers on it for various issues or various allegations relating to discipline. And that happened every week, once a week, for 25 years. All of a sudden, the year 2020 comes up. You remember that, right? Just around the time and the issues of COVID. We all remember it very well. But things began to change. And what changed? What changed, as we know, is that there was a city settlement going back, and then I'll go forward. In 2016, the city settled the Nunez case. What was that case? It was a case where the city of New York was taken to court because there were various issues presented in terms of how the Department of Corrections were treating different people in custody and what was happening with correction officers. There was mass litigation on the issue. And so what ended up happening is that a federal monitor was appointed in terms of overseeing the Department of Corrections and overseeing the steps that the department was taking. That changed the universe completely. So we went from a situation for 25 years plus, that's a quarter of a century, where you had 10 officers, again, I say it not by being redundant, but by being clear, going to oath. That's about 40 a month, right? 20 every Wednesday at Rector Street in Lower Manhattan, to a situation where the federal monitor imposed different standards. In talking about the federal monitor and the Nunez consent decree, and in talking about what happened with discipline, it's important to understand that over the years there was a backlog that developed. What is a backlog? A backlog is where there are officers who are pending discipline whose cases, for whatever reason, weren't going forward. So the federal monitor issued a number of mandates and a number of remedial orders which required the department to increase the amount of officers who were going to oath. And so in 2020, you had a situation where initially the monitor said, no longer are we going to do oath 1 day a week, we're going to do it 6 times a month. And so began in 2021, where you entered into a situation where the 1 day 10 calendar was no more. You ended up having on the first and third weeks of the month, 2 days a week where you'd have 10 officers on the calendar. Why? Because there was this backlog that predated the 2020 term that had to occur. And so in order to address this backlog, what occurred was you had the imposition of more cases that were being held. And then the federal monitor, in order to clear the backlog, then said, guess what? We're going to go from 6 days a month to we're going to go to 3 days a week. You heard me right. So now, all of a sudden, when you had a quarter of a century of going to oath 1 time a week, you're now at oath in a situation where you're there 3 times a week. So that's 30 cases a week instead of 10 cases. Wow. So you have a backlog that's being addressed, and then you have a monitor that's saying, now we want you to go to oath triple the time. It's important to know and understand that because it gives you a sense of why there's this discipline. So that's the issue in terms of the enhancement of the amount of officers going. But here's the good news. The good news is that you're getting more command disciplines than ever before. What does that mean? It means that cases are being resolved in a way where if you're being disciplined, the case disappears after a year. The good news is that there are cases that are being administratively filed. What does that mean? Dismissed more than ever before. I'd argue because they shouldn't have been there in the first place. So yes, there was an increase based on a federal mandate of discipline, but there's also discipline that's happening where it's being blunted, stifled, and officers being protected because of the fact that the results have been outstanding. And that's not the work simply of this law firm. That is the cooperative effort of the Correction Officers Benevolent Association and the board members working with the lawyers to get great results from officers. So that's the first step in terms of history. And then there's this issue of, there's all these suspensions more than ever before. Slow your roll. Here's why. What happens is, under New York State law, the department is allowed to summarily suspend an officer. What does that mean in English? It means suspend now and ask questions later. But guess what? Even though they have that legal authority, they being DOC, the Department of Corrections, once the case goes to oath, if you've been suspended improperly, you get your money back. It's called back pay. And as a result of the excellent work of the various executive board members who work with us at oath and of the exceptional attorneys here, we're getting back pay. So they take your money up front, but we get your money back. And we're very happy about that. And then there's the final component of it, which is there's more terminations than ever. Again, everything has a context, because that's not true. The reality is that there's a renewed focus on medical separation and medical incompetence cases. It used to be back in the day, for a quarter of a century, with these medical cases, that there was nothing to see here. But because of the federal monitor, because of the politics, because everyone's watching corrections, the reality now is that cases where the law says that you can be separated, right, medically separated, that is, removed from the department is exercising their right under the law to do exactly that. Well, what right? In the event you're involved in a use of force, there are 2 years that you can be out before the department separates you. But make no mistake about it, after that second year, they're exercising the option to do that. If it's not a use of force case, the department can, after 1 year, separate you, and they're exercising their right to do that, but not so fast. In the event, for example, that they're transgressing your rights and not making movements that are legally proper, we are getting these cases dismissed in record numbers. We're getting cases dismissed on medical sympathy grounds, where we're asking the department to look at the facts, look at the issues, look at what happened to the officer before you look to remove them. So next time you hear more discipline, more suspensions, more terminations, now you have the historical perspective, knowing that this is a combination of various factors leading to the enhancement of discipline because of the federal monitor, because of the backlog, and because of the climate of the times. At the end of the day, there's exceptional work that's being done for every officer. We're fighting to protect you, to defend you, to dismiss your case, to get you command disciplines, to get you back pay, and to make sure that you and your family are protected and remain protected. God bless you.